Today's topic of environmental law is on sustainable development, in which we will be further looking into the role of the Indian courts in further strengthening the concept of sustainable development in India. If we talk about the public trust doctrine, it was first time invoked in the case of MC Mehta versus Kamal Nath, this case of 1997. And in this case, from that time, it has been, when it was being first time invoked, from that time, it has been used as a very effective judicial tool in order to protect and preserve the environment. In this case, the news item was appeared in Indian Express stating that a private company known as Span Motels Private Limited, in which the family of Kamal Nath, who was the former minister at that point of time, Minister of Environment and Forest, had direct link and had built a club at the bank of River Bias by encroaching land, including substantial forest land, which was later regularized and leased out to the company when Kamal Nath was the minister for environment and forest. It was stated that the motel used earth movers and bulldozers in order to turn the course of River Bias, and the efforts on the part of the motel was to create a new channel by diverting the very river flow. According to that news item, the three private companies were engaged to reclaim huge trust of land around the motel, and the main allegation in the news item was that the course of river was being diverted to save the motel from future floods. Supreme Court in this case initiated suo motu action, and based on that newspaper item, because the fact disclosed that if it was to be true, it would have had a very serious act of very serious environmental damage, and it was a serious act of environmental degradation. And the issue before the court was that whether Span Motel Private Limited violated public trust doctrine. And in this case, the Supreme Court interfered. Supreme Court held that the Span Motel interfered with the natural flow of the river, and by trying to block the natural relief, and thus endangered the ecology of the region. And the court observed that ordered the cancellation of the lease in favor of the motel, on the ground that the area, being ecologically fragile and full of, scenic beauty, should have not been, in the first place permitted to be converted into a private ownership and to be used for commercial gain, which was also considered as a breach of public trust doctrine. And court further observed that the public trust doctrine, which primarily rests on the principle that the certain resources like air, sea, water, forest have such a great importance to people as a whole that it would be wholly unjustified to make them subject of some private ownership, and the said resources, which are common to all, being a gift of nature, they should be made freely available to everybody, and irrespective of the people's status in the life. And the doctrine also enjoins upon the government. It lays responsibility on the government to protect the resources for the enjoyment of the general public, rather than to permit their use for private ownership or commercial purposes. And it was further observed by the court that our legal system, based on English common law, includes that the public trust doctrine as part of its jurisprudence, and the state in which a state is a trustee of all natural resources which are by nature meant for public use and enjoyment. Now, public at large is the beneficiary of the natural resources like water, air, forest, and ecologically fragile land. The state as a trustee is hence under a legal duty that they have to protect the natural resources. These resources are meant for public use and hence cannot be converted into private ownership. As we have seen in the case of Kamal Nath versus MC Mehta versus Kamal Nath, the case of 97, we have seen that the Supreme Court has applied the doctrine of public trust and said that the aesthetic use of pristine glory of the natural resources is very much required when the question is of environment and balancing the ecosystem of our country, and it cannot be permitted. The use of natural resources cannot be permitted in a manner that it erodes the pristine beauty just for the private commercial purpose or any other purpose, unless and that is necessary and court find it's necessary, that it has to be done in the good faith or for the public good or for public interest, and then only encroaching upon the said resources can be applied. But then also you have to it's a responsibility to maintain the balance between the activity and the ecosystem. The next case that we have discussed earlier also in our previous classes is Narmada Bachao Andolan versus Union of India, a very famous case. AIR 2000 Supreme Court 3751. And in this case, precautionary principle came to be considered by the by the Supreme Court, and the court also look at the view that the doctrine is to be employed only in cases of pollution when its impact is uncertain and non-negligible. In this case, a public interest litigation was initiated against the Sarovar project and was considered, and which consisted of the construction of large dam on Narmada River, and the petition alleged that the project would lead to ecological destruction, and that there will be, on the other hand, it was also submitted that there would be positive impact or preservation of, there will be impact on the preservation of ecology as a result of the project, and the project would make the positive contribution for preservation of environment in several ways. The project, by taking water to drought-prone areas and part of Gujarat and Rajasthan, would eventually effectively stop or restrict the ecological degradation, which was returning to make these areas inhabitable, and due to salinity and water and advancement of desert and groundwater depletion, and the water as it was affected by fluoride and nitrate, and led to the vanishing of green cover. The ecology of water scarcity areas was under stress, and transfer of Narmada water to these areas would lead to sustainable agriculture and spread of green cover. And the issue before the court was that whether the construction of dam would lead to ecological destruction or not. And in its decision, Supreme Court balanced the environmental and developmental imperatives, and said that in the balancing process, Supreme Court introduced a very new dimension in the precautionary principle by way of integration between the two. Supreme Court observed that the precautionary principle and the corresponding burden of proof on the person who wants to change the status quo will apply in a case of polluting or other project or industry where the extent of damage is likely to be inflicted and is unknown. And when there is a state of uncertainty due to lack of data or material about the extent of damage that the project or the extent of pollution that is likely to be caused by the project in question, then in order to maintain the ecological balance, the burden of proof the burden of proof will be on the industry which is carrying out the function, and it has to be, or the unit which is likely to cause the pollution, it would be for them to prove that how their action will impact the environment and what they are going to do about it. On the other hand, where the effect of ecology or environment of setting up of any industry is in question is known, and what has to be seen is that the environment is likely to suffer, and then what mitigative step can be taken to to prevent such environmental damage. And it is where the effect of the project is known, the principle of sustainable development will come into play, and which will ensure that the mitigative steps are and can be taken to preserve the ecological balance. Hence, sustainable development means what type or to what extent of development can take place, and which can be sustained by nature, ecology, or with or without mitigation. Court further held that the present case involves the construction of a dam, which is neither a nuclear establishment nor a polluting industry. And also the construction of dam would never, would undoubtedly result in the change of environment, but it would not be correct to presume that the construction of a large dam like Sardar Sarovar would result in ecological disaster. India, has already have a lot of experiences in terms of construction of dams in the past, and the experience does not show that the construction of a large dam is not cost effective or leads to ecological or environmental degradation. On the contrary, there has been ecological upgradation with the construction of large dam. And further, court observed that what is the impact on the environment is well known in India, and therefore Supreme Court held that the precautionary principle would be inapplicable in the present case, and the project would neither violate the mandate of Article 21 of the Constitution nor the concept of sustainable development. Now, next case again that we'll revise here, we will discuss here is that Goa Foundation, Goa versus Diksha Holding Private Limited, AIR 2001, Supreme Court 184. Now, this case has been a lot of time I have discussed earlier also in my previous sessions. You are aware about the facts already. So let's look into it once again with the in the context of sustainable development. So a public interest litigation was initiated against the construction of hotel in Goa, which was considered to be done in the CRZ third in the coastal management plan, and CRZ is coastal regulation zone 3, and it was being contended that it would disturb the environmental equilibrium and biodiversity in the coastal area. And in this case, the court found that the construction of a complex in coastal regulation zone CRZ third was valid, and one more reason was cited, that the construction is not in the non-development zone, nor it will disturb the sand dunes in the area. And it was also observed that the natures of beauty attract tourists from all over the world to Goa, and a provision of infrastructural facilities without adverse effect has thus become a must for the development of tourism industry. Here, in this case, Supreme Court attempted to strike a balance between environment and development, and held that no activity which would ultimately lead to unscientific and unsustainable development and ecological destruction should at all be allowed, and court must try to protect the ecology and environment, and should shoulder the greater responsibility in the society. When we look at the concept of sustainable development, we try to conclude all of it. We see that it requires meeting the basic needs of all, and extending to all the opportunity to satisfy the aspirations for a better life that people are having. And it is true that sustainable development is the need of the hour, and traditional knowledge should be linked to pure science and environmental law, and in order to achieve technology and practices, flood mapping, study of agriculture, climate change impact, water management, food security, and research should be integrated with the concept of sustainable development in order to analyze the fundamental societal challenges in sustainability, because we live in a society where development is being measured in terms of economic growth, and we all focus on urbanization. So the promise of inclusive and sustainable development can only be achieved and we can only make it possible if the key policy decisions are rethought approach, and with clear priorities on urbanization and economic growth, with the transformations kept within the ecological limit, and a vision for new cities has to be developed. There's a focus, that focuses on urban design to modify the patterns of natural resources as well as the consumption pattern of city dwellers to safeguard the environment. And at international level also, the all the stakeholders must advocate a central focus on sustainability along with the human security and equity. And that is where the battle to protect the environment and to ensure sustainability could be it could be won or can be ensured to be won.